Good morning, everyone. Thank you so much for joining us for our November Clear Up the Chaos. I'm wanting to start on time. We have a lot to cover. And with that being said, I'm thrilled to have several individuals from Ironwood Consulting with us to discuss our hot topics for the month. I'm going to hand things over this morning to Christine Beldner, and she's going to speak on all the new OSHA updates regarding the vaccine mandates. I know lots has transpired since our last Clear Up the Chaos, and we were anticipating that.
Oh, what I'll say is you have to roll back. If we change it and then you roll back, it's going to undo our changes. Remember? Okay. Don't go there, Robbie.
Okay.
If you haven't,
God.
if you would kindly everyone mute really quickly. Okay, are we good? So speaking of the OSHA updates, lots has transpired since our last Clear Up the Chaos. So I do encourage you while we're all together to send in those questions via the chat box, and I'm happy to relay those over. And that way we can all have great conversation and learn from one another and take advantage of Christine's expertise. So Christine, thanks for joining us again. We're thrilled to have you and are anxious to hear what you had to share with us this morning.
Thank you, Elizabeth. Good morning, everyone. Hopefully you guys can hear me okay. And I'm also joined with my colleagues, Amanda and Kevin, and we'll get to them soon enough this morning, but I'm just gonna kick things off. And you are definitely correct. It has been a busy month since we last got together. Wow, OSHA has been busy. At the end of October, it's kind of been lost, but the EEOC actually released some clarification about the COVID-19 and ADA reasonable accommodation. So that probably got slipped under everyone's radar. So that's something to be mindful of, and that's a link that we can send you guys. So be aware of that. OSHA also released a COVID whistleblower fact sheet at the end of October. So that just gives you some insight as to how busy of a month it's been. Those weren't even on really anyone's awareness because the emergency temporary standard, right, took center stage. So that was, the interim standard was released 2 days after the elections on November 4th, much anticipated. And of course, then the very next day, the Fifth Circuit Court issued a stay. And I think all of us were wondering what that meant. And so I want to address that head on because some of you might be wondering, do we even need to mess with this ETS now with this Fifth Court stay in place?
Breathing in trouble.
And what I would, we of course reached out to employment attorneys that we trust, and then of course the law community in general has had lots to say, and we've been monitoring that. And the general consensus that we've read, that we've seen, that we've heard is that everyone is saying prepare, continue to forge ahead as if the ETS will stand, and that's not an indication that the courts will side that way, but the reality is if the appeal is struck down, then employers will not have any extra time afforded to them to prepare. It's not like the ETS will have a new date to be afforded. It will be basically the dates that are currently in place will continue to stand. So the December 5th date to comply and the January 4th date to comply that we'll get to, that we'll speak to later on, we're anticipating would likely stand if the appeals don't stand. So the law community is encouraging everyone to proceed, prepare, plan, and that's what we're encouraging as well. So that's why we're here today, and that's why we think it's prudent that we continue the discussion, that we go ahead and unpack this ETS, and that's what we're going to do here for you guys this morning. To give you guys a little bit more insight into the fifth court of appeal, what's happening with that is that the government had until yesterday to actually respond to the stay, and then the petitioners have until the close of business today to actually respond to the government's response. So that's actively moving forward. It's something that is moving fast. So it's not like that's going to be a process drawn out for a long period of time. So there will be ruling quite fast. And of course, we know there's multiple other lawsuits that have been filed in other courts, but we anticipate all that moving fairly quickly. So that's, again, another reason why, as employers, we need to continue to prepare. The good news is that, you know, we have been reading this 500 page. We talked about that. Elizabeth asked us how big is this ETS that kept Amanda, Kevin, and I busy this past weekend. It's almost 500 pages. We've fallen asleep all weekend long reading this guy. The good news is that it is doable. You know, whatever that looks like for you, we know there's lots of opinions, and every company, every individual certainly is afforded their own, you know, opinion, but we're here to tell you today that there's all ways that you can implement this. It's definitely something that you can make happen at your company, and we're here to help you do that. At Ironwood, we've already laid out what we believe are the documents that can help with compliance, and we plan on putting those documents together and offering those sample documents for free to our partners like NCW for them to use for their clients. So we want you to kind of go into this as we start and kind of peeling back the layers of this onion. Don't start with panic, like, oh my gosh, this is so much. Let's go in and just have the mindset that Ironwood already has a lot of this planned and covered for you, that we're going to kind of put it all together. All right, so what does it say? So some of the basic requirements. You must implement a mandatory vaccination policy. That policy can have an exception that allows employees to not be vaccinated so long as they undergo weekly COVID testing and they wear a face covering. So I'm going to go ahead and state that again. Mandatory vaccine for everyone is one option. Another option is mandatory vaccine, or they can decline being vaccinated so long as they undergo weekly testing and they wear face covering. Okay. Next requirement. Employers will have to maintain a list of vaccination status of each employee, and they have to obtain proof of vaccination. Now, if you have been an employer that has already obtained proof of vaccination, if you were forward thinking and that was something that you've already put in place, in the ETS, there's actually a provision that you don't have to go back and do that all over again, so long as you already have that documentation in place. So that's great. But if this is something that you haven't done yet, you will have to do that. And in the ETS, it's very specific about what type of documentation constitutes proof. Things like copy of the vaccination record card or medical records. There is actually an option should none of that exist, or if you have an employee that says, look, I have actually lost the one piece of evidence I have, an employee can provide basically a letter attesting to the fact that they lost their one documentation. And Ironwood plans on drafting that template for you as a tool and as a resource. Those are likely going to be the exception to the rule. It's likely that your employees, the majority, 99 out of 100, should have some kind of proof under the acceptable list of proof of vaccination available to them, because it's pretty normal records that they should have. And a lot of it is just, you just need a copy. And then one of the examples they gave was just keeping like an Excel spreadsheet would be sufficient in terms of record keeping of maintaining those records. Another requirement is that employees will be afforded up to 4 hours of paid time off to receive each primary vaccination dose. So if your employee is going to receive that Johnson & Johnson, that would be the 1 dose vaccine. So that would be 4 hours to facilitate receiving that vaccination. So that would be, again, that time to schedule it, to drive to and from, to fill out any paperwork necessary for them to at the doctor's office or the pharmacy, wherever it is that they're choosing to get it. And then if they're receiving the Pfizer Moderna, that would be 2 separate vaccine doses. So our interpretation is that that would be 2 instances, 4 hours separately to receive those doses. At this time, boosters are not covered, is our understanding, our interpretation. So it wouldn't be 3 instances with the boosters, it would only be 2 instances of 4 hours. In addition, paid time off to recover from any side effects experienced following each primary vaccination dose. So they haven't defined 100% what reasonable side effects might be and what that might look like. I think Kevin did some further research and found that it's looking like up to 2 days following each. So again, we will probably include that in our draft policy, but employers can anticipate ensuring that your policies have at least 4, if your employees are looking at the 2-dose vaccines, having at least 4 days afforded for employees to have sick leave to recover from those side effects in total. Amanda, is that accurate? You were shaking your head. Okay.
Yes, they said that.
Okay. All right, continuing on with the requirements. Ensuring that each employee who is not fully vaccinated is tested at least weekly. So this is calendar week. So on every 7 days, if they're in the office or in contact with someone else. So if you have an employee that works from home, they would be excluded unless they're anticipating on coming into the office, then they would need to be tested 7 days prior to coming into the office. And they note various ways that testing could occur. Testing could occur through, they suggest employers can set up testing on site. They could partner with a pharmacy or a doctor's facility. They can partner with a facility that sends testing to employees' homes, things of that nature. What's important is that employees cannot self-administer and self-review the actual test. So I know a lot of the tests are available right now at CVS or Sam's, so we can't go do the at-home test. So employees can't purchase the at-home test, take a picture of it. It's negative, take a picture of it and send it to their boss and say, I'm negative. That will not be allowed. So now an employee can administer the test in front of the employer, and that would be considered acceptable. So that could be an approach that makes it testing possible. So we can talk about that more. And that's one of the things that Elizabeth, I know we plan on mentioning, that Ironwood's going to offer 2 more extensive webinars tomorrow. We're going to go into more specific details about all the specifics of the ETS, and that's going to be one of the areas that we're going to cover in more detail tomorrow.
So Christine, can
Yep.
you speak to, or has it been addressed, who right now is going to be paying for all this? I mean, if an employee says they're not going to get vaccinated, who is responsible for paying for all these tests?
So the employer would not be responsible. The way that OSHA looks at it is that they really consider the best defense is vaccination. And so if the employee chooses not to be vaccinated, then the cost of testing they judge to be the responsibility of the employee. Now that the employer can opt to pay for it, but ultimately it's the employee's responsibility.
So then it can be up to, I guess, the employee, if they're the one purchasing, or if they're the one being asked to purchase, it can be up to them on the type of test, the brand of test. I mean, then we get into a whole, because I know there's different tests out there and some are more expensive than others. And so if it's up to the employee, the employer can't really mandate a certain brand, or is that correct?
Actually, it would come down to the employer policy. So the employer could actually dictate what they will allow in terms of their policy. You know, the employer could dictate, we will only accept
Through this pharmacy or
through right
this brand.
Correct.
Okay, and then that's something that an employer would put into their vaccination policy.
Correct.
Okay, thank you.
So regardless if an employee is vaccinated or unvaccinated, should an employee test positive, the employee within the policy, the employee would be required to immediately notify the employer, and the employer would then have the obligation to immediately remove the employee from the work site. Regardless, again, of that vaccination status, then the employee could not return to the workplace until the normal return to work criteria are met. And that again could be met through a variety of ways, which we can cover in more detail again tomorrow. But again, there's the CDC return to work criteria that can be met. It could be met through a negative COVID test, but now, of course, what we know now is that most people continue to test positive for a significant period of time. So there is a variety of ways that an employee can return to work, but they will not be able to return to work through that period of time. And again, that has to be in that vaccination policy. All right, continue on through the requirements. If you have that policy that states that employees who opt to not be fully vaccinated can continue to be employed. They must wear a face mask indoors or when occupying a vehicle with another person in that vehicle for work purposes. In addition, another requirement is there's a lot of notice requirements. So you have to provide several different notices. One is the requirements of the ETS, the actual policy that you're going to be putting in place, the vaccination policy that you're going to be putting in place to implement the ETS, the actual CDC document. It's called Key Things to Know About COVID-19 Vaccines. And then there's 2 other documents that are already in place, the protections against retaliation, discrimination, and then laws that provide for criminal penalties for knowingly supplying false statements and documentation. So those are 3 of those are basically general notices already, and then your typical policies.
Can you share those 2 as well, Christine?
We will.
Okay. And then I've had another question come through. So you may be
Sure.
getting to it, but I just want to make sure. So someone has asked, does vaccinated include getting the booster? Specifically, if someone is vaccinated, but this individual is adamant about not getting the booster, are they still considered vaccinated?
Yes, right now, fully vaccinated is considered the 1 Johnson & Johnson or the 2 Pfizer and Moderna. Following the 2 weeks after
That period.
that period, yes.
Okay, thank you.
All right, continue on with, I only have 2 more requirements that I'm gonna highlight. Again, of course, keep in mind, it's a 500-page document, so we're just kind of giving the highlights, and then I'm gonna turn it over to Amanda, and she's gonna kind of go a different direction of some other aspects of the ETS. Again, the requirements to report COVID fatalities and injuries in terms of your typical OSHA reporting requirements, that doesn't change. And Kevin will speak to the implications, excuse me, of not complying with the ETS a little bit later in our call today, but your reporting requirements are no different than any other workplace injury or fatality. So keep that in mind. The ETS did highlight some different record keeping requirements. The medical records, again, of keeping the vaccination records of everyone are not going to be subject to the 30-year requirement of medical records. They did put an exemption in for that, which was nice. However, they did say that you basically can't fake it. You can't say, oh, yes, we're going to have this policy and we're going to act like we're going to do all this stuff and then not do it, because you have to be able to produce these records should OSHA ask for them within, I want to say, within like 24 hours or 4 hours, I don't recall. We'll have that information in the briefing tomorrow, but it was a very quick period of time should an OSHA representative ask for it. It was highly unusual and it was very fast. And they also have to be available to an employee or an employee representative for examination and copying. So you're not going to be able to fake compliance. And what we do know, and what, again, Kevin will speak to, is OSHA is anticipating for employees to basically be their reporting agency for compliance. So if you are, again, and not going to be taking this seriously, if you have one kind of employee that's disgruntled and they're going to be your person that's going to be calling that hotline, you can't anticipate getting that phone call. So again, we're going to set you up for success and make compliance possible. We want you to know that it is going to be possible. It is really going to be more paperwork than anything, and it's going to be doable. So I want to turn over to Amanda for a little bit. She's going to cover other aspects of the ETS to kind of help you decipher, okay, am I a covered employer or not? Amanda?
Thanks, Christine. Good morning, guys. As Christine mentioned, further than just going over the basic requirements, when we were reading through all of the materials, we wanted to kind of hone in on some of the questions that may be less clear, or some of the things that as you're deciding what you want to include in your policies and procedures, or which direction to go versus a full out mandate versus having both options, some of the things that you'll want to consider and start thinking through. So we want to mention a few of those things, not that you're going to have the answers for them right now, but that you need to start thinking about as you're forming your policies. So to start out, to figure out if you are included within this 100-person private employer, even that 100 number, it has all sorts of questions within it. So what OSHA has said is that if you have 100 employees at any time while the ETS is in effect, so that would be from November 5th last week when it went official, potentially from 6 months from now, potentially into the future, depending how all this shakes out. At any time, if you have 100 employees, you must abide by these standards, even if you have 100 for one day and then it drops below that. You have to continue to abide by meeting all of the components of the ETS. So at any time, if you have 100 or more employees total, that 100 number is based on your company-wide or corporate-wide headcount, meaning it's not going to be broken down by, I have 20 people at our office in Dallas and 50 people in Houston and 50 people in Lubbock. That would be all 120, so you would all be covered in that case. It's not broken down by website, worksite in any way. Further within that 100 number is that you are going to include all of your full-time workers, all of your part-time workers. If you have temporary employees that are actually your employees, they're just on a temporary basis, meaning you've hired them, not through like a staffing agency, all of those people are counted as one. A 10-hour-a-week employee counts as one employee. So those would all go into determining that 100 number. Who's not included is any of your independent contractors and any leased employees. So that would be more like somebody through a staffing agency that's just with you temporarily, but the staffing agent is the employer of record. There are some exceptions, and this is where it starts to get a little dicier as far as who's actually going to be covered within your employees. For those that work remotely or exclusively outdoors, which is a little more detailed than that seems, is what's considered both remote or exclusively outdoors. And the catch for those people is they would still be included in the counting of your 100. Let's say you have 120 employees total and 100 work from home. For determining whether you are covered under the mandate, yes, you've got 120 employees. It may be that those 100 that work from home don't end up having to become vaccinated, but for the count coverage, they're included. Same with those that would work exclusively outdoors. For determining whether the ETS applies to you, you count them as employees, even if their specifics might end up being a little bit different. So that's some things to think about when you're trying to figure out, especially if you're real close to that 100 number, whether or not you are actually included within this ETS. Next, we kind of wanted to look at determining which direction to go based on your current employee's vaccination status. You may or may not at this time have a pretty good idea about the percentage of your workforce is vaccinated or not. You could have gone either direction with that until now and would have been perfectly justified in that decision about wanting or needing to know. But getting a introductory understanding of what that looks like might help you determine which way you want your policy to go. If 95% of your employees are already vaccinated, you've got a smaller hill to climb if you want to go with a full mandate versus if only 10% of your employees are vaccinated. So it may or may not affect you, but it might be something to keep in mind to just get your head around which direction might be the best strategy. But again, as Christine mentioned, you'll be required to know whether all of your employees are vaccinated or not and keep a roster up throughout the duration of the ETS at all times as far as vaccination status of each employee. And then down the line, it's going to also include where they might be in the vaccination process. You'll also want to think about, when writing your vaccine policy, how your employees should go about notifying you about vaccination status. Just who's going to be responsible for that? Is it going to be at the department level? Are you going to have one main source of contact? There's going to be a lot of upkeep as far as keeping up with records. So keep that record keeping component in mind, and that ongoing need to be updated about each employee's status as it changes throughout the course of the ETS. So that's something to think about and keep in mind. If you are considering a policy where you are going to allow the weekly testing and masking, or you anticipate even that needing to be an option because maybe you already know about some accommodation or religious exemptions that may be a part of your employee population already. But if you're trying to consider which direction to go, again, one of the big things you'll probably want to think through is just the accessibility to testing. We talked a little bit about this earlier, but if you are going to allow the weekly testing, how many testing locations are near your workplace? I'm here in the center of Houston, and I could probably go to 5 locations within a mile, but that may not be the case for people in more remote work areas. So how accessible? What are going to be the hours of those testing locations? How long is it going to take to get those results back? Are they open on the weekend? Are they only open during the day? Are they only open from 9 to 5? Thinking through that logistical aspect of how is this going to actually work if a large part of my employee population is going to need time off every week to go get testing. Thinking through that, and even, again, as Christine mentioned, some recommendations have included, especially for larger companies, would it be easier to try to coordinate with a testing site so that you could send people at a specific time or have bulk testing come out to you? And so think through what that might actually look like. And then again, which types of tests you're going to accept. And I know we had an earlier question about that. Within the ETS itself, it essentially says, any FDA approved test. So whether that be the rapid test or one that needs to go to the lab. And the only caveat was the tests that you buy over the counter, do have to be FDA approved. And then, as Christine mentioned, it can't be self-administered at home without any witnesses. It either has to be done in front of a medical professional or in front of your employer to actually do the self-test itself. And so in thinking about that as testing options, then from there, of course, you want to consider your costs. Under all of the previous COVID laws and regulations, they accounted for free COVID testing, whether you had insurance or not, for everyone if they had COVID symptoms. So, before now, you either had to call a doctor, or you had to fill out a webinar, or fill out a online form, with symptoms. And if you had enough symptoms, then insurance or the government would pay for your testing for free. But none of that is covered when it's just for general employment purposes, meaning you may not have any symptoms at all. This is just weekly testing. There's probably going to be a cost involved no matter which type of testing you allow. And again, like we mentioned before, nothing within the ETS itself requires employers to actually cover the cost of testing. And again, you can opt to pay for that if you think that that's going to be an issue for your employees. But unless it is required by the laws of the state, which for most of us here in Texas wouldn't normally apply, or any sort of other local regulations, the employers are not necessarily on the hook for this unless they want to be. Another piece of that to remember, if you have employees working in different states, would be to check where the laws of the corporate or main office is, but also the states where they perform work. So if you've got people all over the country, you might need to look at several different state regulations and just make sure that you are in compliance with everyone. The other piece to keep in mind as far as cost, just to make things, one more step in complication, is that if the employee pays for the test, there's going to be some minimum wage issues that factor in potentially. If the cost of the test were so large that it brought that employee's weekly wages down below minimum wage, then the employer might have to pay for some of the testing or make sure that the employee still ended up getting paid at minimum wage. And again, that could also change based on some state laws too. So you'll just want to make sure that that is the same at whatever state you are operating or your employees are operating in.
So Amanda, if we can just take a quick break for a second. Sorry, I'm getting flooded with questions. So
sure.
I want to get some of these addressed before we get any deeper, if you don't mind. So are you suggesting that all companies need to start keeping records of requirements, or are you still saying if you only have 100? I mean, let's say you're at 90. Are you suggesting that an employer start taking steps if they know come the new calendar year they're going to have growth? I mean, what are your suggestions there?
It would probably be a good idea to start coming up with these policies and procedures. If you're definite you're going to go over that 100, you might want to start with the paperwork or the record keeping components. If you're sure, that would just be getting a leg up on things. But you definitely want to be thinking the policy and procedure parts through.
Okay, if a person refuses to get vaccinated and then fails to test weekly, and the organization decides to release the employee, will they be eligible for unemployment?
Amanda, I'm thinking you and I might have to research that one and get back. I think that one's going to be tricky. I think the intent of the ETS would dictate, no, they're not going to be eligible for unemployment. The caveat is Texas is, if you're in Texas, Governor Abbott has a different mentality. And it could advise TWC to take a different approach. And so we may not know the answer to that until that actually plays out. But I think if you look at the overall ETS mentality, and you're in another state, the answer would be a resounding unemployment would be denied. Amanda, do you have a take on that?
I would agree with what Christine said. Everything within the ETS, I think it's even in the frequently asked questions, says that they would not be eligible for unemployment. But as Christine said, that might be different from state to state.
So we'll take that one as homework, if that's okay.
That's great. I have it on my pending list. So if y'all don't mind doing a little bit more research. Okay, back to our question board. If you go to 100 employees and you subsequently fall below the 100 number, are you no longer under the requirement? If we decide to terminate to get below 100 today, does that keep us out of requirement pertaining to the 12/5 effective date?
No, as of how the ETS is written right now, at any time, if you are at 100 since November 5th, when it was filed. So it's essentially too late to do that.
Okay. How is the PTO reimbursed to the company? Is that on form 941 each quarter?
I can take that one. PTO is not reimbursed.
Here we go. Okay. Regarding the unemployment insurance, if eligible, will the employer account be charged?
I think that's going to need to tag on with the unemployment question before. I think that's going to be determined possibly by which state you're in.
Do y'all have an idea? I know you mentioned the sample policies. Do you have an idea of when those sample policies will be available?
Christine, what do you know? what do you think are, and we're only kind of chuckling because there's about 10 different policies in there to have ready.
We need to get through kind of tomorrow and kind of preparing the briefings, and then that'll be our next priority. So I would say middle of next week, end of next week.
Yeah,
definitely before early December when it's go live. So we do have some time.
Okay. And then another question, if employee pays, do we have to, I think they're referring to payroll deduct. Can we require they arrange themselves for an approved provider test and then provide the results and the employee pay on their own?
Oh, definitely. Amanda, is that how you're taking that? That they can basically just bring the results? There's requirements on basically what the results need to contain, basically identifying information, name, some other kind of identifying information like date of birth, the provider who actually took the results, what type of test it was, and then whether the results were positive or negative. So as long as the results contain that information, that's all you need to say that you got test results. So you could care less about how they paid or where they went or things of that nature. So your policy can be that flexible.
If an organization gives PTO to their employees, but they have used all their time, could the organization advance PTO to the employee for recovery time?
You're not allowed to let the employee go negative or anything of that nature. Amanda, I know you've gotten more into that section than I have. Do you want to kind of expand on that at all? Or Kevin may be able to chime in too. I know he's more familiar too in that section.
Yeah, for the one thing that they really want to split hairs on is the PTO versus sick leave. And if you only have sick leave or you only have PTO, they're handling it differently, but they're really adamant about not going negative on sick leave. So if the employer cannot mandate that they use the mandate that they use the PTO, but they can mandate that they use available sick leave. Does that sound right, Amanda?
We'll clarify that specific question and we'll get you back a very specific answer. So Elizabeth, you capture that one too as pending, because I know that sounds more vague than we would like to give, but the regulation in terms of PTO versus sick was pages long.
Right.
So we have to be very careful in how we respond to that.
I will capture the question and we'll
Okay.
revisit. Can you choose to have a manager or an on-site employee be the certified tester?
Yeah, they can certainly monitor that employee getting the results and things like that, purchasing those at home do-it-yourself tests for sure. That was my take on it.
Okay, the next question.
Amanda, you 1 second. Sorry, it sounded like Amanda wanted to chime in.
No, I don't think it spoke to who has to watch it within the company. I think you're correct. I think it just someone has to monitor it.
So you mentioned that outdoor employees are exempt. We currently have 90 employees, only about 10 in the office. The rest work outdoors daily. They're never in the office. If we go over 100, would only the office personnel be the ones having to be tested?
Yes and no. In theory, if they worked 100% of the time outside, meaning they never went into the office, they never went to the bathroom, they never shared a vehicle, it's one of these kind of gray areas about what is exclusively outside. If they did truly work 100% independent and outside, then only the office staff, if you went above 100, would have to be vaccinated.
You need to come to the webinar tomorrow, is what that means. If you're one of those people that have outdoor employees, we're going to talk about outdoor employees tomorrow.
So I'll share more of that information at the end, but Ironwood Consulting is having an additional webinar 2 different times, and I'll share that at the end of our webinar today. So lots of questions. I'm going to hand it back over. I don't know, Amanda, if you have more, but wanted to get caught up on those questions.
No, that was great. That actually, that covered a lot of what we had left. I mean, the last thing I had was, to think through your paid time off requirements. And like you said, we're going to get you some more detailed information about that because, like we mentioned, we know that it says 4 hours for each of the vaccination appointments as far as scheduling, getting there, getting the test, waiting your 15 minutes afterwards, going home. And then that kind of vague, reasonable amount of paid time off for any vaccine related side effects, which later in the Q&A, it says that OSHA will accept 2 days of paid sick time per vaccination. But thinking through that sick leave and PTO piece, which we said we'll get you some more information about, especially if, a large percentage of your employee population doesn't have sick time or if you have your combined PTO and sick time. And so really then just the last piece, and again, we touched on a lot of this with our Q&A, so that's great. You guys are ahead of the game. Was just thinking through your reporting and record keeping procedures. within your policy, you'll want to establish that employees have to very promptly report either a positive COVID-19 test, or if they were to go to the doctor and get a presumptive COVID diagnosis, perhaps sometimes that's given before the tests that take 2 to 4 days to come back. That would still be considered a positive diagnosis. Again, keeping within your policies that the employee would be immediately removed until that CDC return to work criteria is met. Making sure that you are aware that any COVID-19 work-related fatalities have to be reported to OSHA within 8 hours of you learning about them. And any work-related COVID inpatient hospitalization reported within 24 hours of learning about them. And actually, that's a pretty good segue, because Kevin's going to talk to us a little bit more about some of the failures to comply from the OSHA perspective and how we anticipate them monitoring this.
Yes, absolutely. Thanks, Amanda. So I'm going to talk about the fun stuff. We're going to talk about OSHA. We handle a lot of OSHA investigations, a lot of OSHA complaints, multiple per month. And the reality is OSHA has been quite vocal in this 500-page document about they anticipate employees to be self-monitoring for them. The reality is it's not a 0% chance, but it's near 0% chance that OSHA is just showing up your door tomorrow. They're going to need probable cause, and they are anticipating that they're going to allow the employees to be their monitors. So the way that OSHA gets a probable cause is either through employee complaints or through self-reporting. So let's talk about the self-reporting first. So OSHA did change a very key requirement. Some of the requirements in regards to record keeping and reporting, the company that keeps their vaccination policy and their OSHA logs and the number of employees that are vaccinated and not vaccinated, those are required to be produced to OSHA within 4 hours of a request. So your policy on vaccination, your number of employees that have been vaccinated and have not been vaccinated, your total employee count, and your OSHA 300 records, if you're required to keep them, are required to be produced within 4 hours. All other documents in relation to COVID that we've been talking about in these policies have to be produced within the end of the day of the next day. So that's your record keeping requirements. But when it comes to what are you required to report to OSHA? And this is where we like to help you split hairs in regards to reporting to OSHA. So under the OSHA, the old OSHA rules, basically, you have to report an inpatient hospitalization within 24 hours of a work-related injury or illness. And under the old requirement, you had to report within 8 hours a fatality, a work-related fatality of within 8 hours of the event, or within 30 days if an inpatient hospitalization resulted into a delayed fatality. You had to report within 30 days. OSHA's changed that. Now, if it is a work-related, and this is the key here that we'll talk about later, we'll talk about more tomorrow, and always call us. If it's a work-related COVID case, you're required to report to OSHA no matter when it occurs, if it results in a hospitalization within 24 hours of you learning of the inpatient hospitalization. And there's no time limit on reporting a COVID work-related fatality. That is only right now going to be active within the ETS timeline. So if this ETS expires and OSHA does not come out with a permanent standard, which honestly we fully expect that they will, they're already developing it. If they don't come out with a permanent standard to address this, this requirement goes away and we go back to the old rules. So the first reason that OSHA is going to come out would be because you actually called them to report a work-related COVID exposure that resulted in a fatality or hospitalization. The reality is OSHA is going to be rocking busy on the employee complaints. They fully expect the employee to complain to OSHA that my company's over 100. My company says they're exclusively outdoors, but they're not. My employees, aren't working 100% from home. They're not complying. So what's that mean? What's going to happen is you're going to get sent a letter from OSHA. OSHA is very, very, very unlikely to show up based on that complaint because they're going to be getting thousands of complaints. They're just not big enough to manage all the complaints. They're going to send you letters, and they're going to send a letter that we've got a complaint that you're not complying with this new regulation. Okay, this is where you're going to get yourself in trouble. You got two directions once you get this letter. You're either going to tell OSHA, go pound sand. I'm not going to comply because I believe it's my right. Or you're going to say, we're complying. Here's all the policies. All our guys are getting vaccinated. Either way, you've got a document that you submitted to the federal government that says, go pound sand. And OSHA is going to be on your doorstep the next morning saying, we're here to do a full investigation. Or we've got full compliance, and that's great if you're complying. But if you're trying to paper the compliance, that same employee or that next employee is going to complain in a week or a month or 6 months from now saying they said they were complying, but they're not. And OSHA is going to show up. Either way, they've got a written document that now says you're willfully violating the OSHA standards, because the first document you told them to pound sand. The second one you fibbed and said we're complying, but you're not, because OSHA shows up from that next complaint. So be very mindful once you get that complaint letter, what that means. If OSHA were to cite you as a business, if you have something in writing that you knowingly are violating these regs, you're looking at up to $140,000 in citations per occurrence. If they don't have a proof of willfulness, then the serious citation could be up to about 13,000 and change per occurrence. So just keep that in mind. We're definitely going to go deeper into this down the road. I think there's some questions that happened. I know we're kind of getting up to our timeline, so I'm going to answer Elizabeth's question.
Thank you, Kevin. Lots of information. I do want to just remind everyone, if you were to be contacted by OSHA regarding a letter or whatnot, we highly encourage you to contact myself immediately, and I can put you in contact with Ironwood Consulting, or if you do have an agreement in place, go ahead and just reach out to them directly. But we never want you to try to handle that situation on your own. We have experts in our back pocket, and we want to just make sure that we utilize them, especially in a time of need like that. So a friendly reminder, I do want to make everyone aware of this, and I will be sending information as well in the follow-up email later today. But Ironwood Consulting, this crew right here, and some additional individuals, they are going to be putting on a very in-depth webinar tomorrow, diving deeper into this ongoing COVID vaccine mandate. And those times, they have 2 different webinars tomorrow. They're taking place at 10 a.m. and 2 p.m. Central Standard Time. So mark your calendars. And again, I will be sending out the information for, it looks like it's are y'all doing a Zoom or a WebEx or Zoom?
Zoom.
So that's all included in this as well. So I will be sending that out. And I just want to remind all of you, as a client of NCW or Sanford and Tatum, you do have access complimentary to Ironwood Consulting. So if you haven't already, and again, in the follow-up email, I'll be including the agreement. If you haven't already, I highly encourage you to get that filled out and completed, so I can begin sharing all these sample documents that they're speaking of, because I think those are going to be a huge advantage for any employer to utilize and not have to start from scratch. So as always, y'all, thank you so much for your time. I thank you to all of you who took time out of your day to join us, and I'll be sending out that follow-up email. And if any questions come to mind between now and the end of the day or the week, feel free to shoot me an email, and I'm happy to get that information over. Thanks so much, and y'all have a great week.
Thank you.
Thank you.
Bye.